Domestic definition of genocide in United States. USC Title 18, Section 1091, A. Basic offense. Whoever, whether in time of peace or in time of war, in a circumstance described in subsection D, and with the specific intent to destroy, in whole or in substantial part, a national, ethnic, racial, or religious group as such. 1. Kills members of that group. 2. Causes serious bodily injury to members of that group. 3. Causes the permanent impairment of the mental faculties of members of the group through drugs, torture, or similar techniques. 4. Subjects the group to conditions of life that are intended to cause the physical destruction of the group in whole or in part. 5. Imposes measures intended to prevent births within the group, or 6. Transfers by force children of the group to another group, or attempts to do so, shall be punished as provided in subsection B. Punishment for basic offense. The punishment for an offense under subsection A1, in the case of an offense under subsection A1, where death results by death or imprisonment for life and a fine of not more than $1 million, or both, and 2. A fine of not more than $1 million or imprisonment for not more than 20 years, or both, in any other case. C. Incitement offense. Whoever in a circumstance described in subsection D directly and publicly incites another to violate subsection A shall be fined not more than $500,000 or imprisoned not more than 5 years, or both. D. Required circumstance for offenses. The circumstance referred to in subsections A and C is that 1. The offense is committed within the United States, or 2. The alleged offender is a national of the United States, as defined in Section 101 of the Immigration and Nationality Act, USC 1101. E. Non-applicability of certain limitations. Notwithstanding Section 3282 of this title, in the case of an offense under subsection A1, an indictment may be found or information instituted at any time without limitation. Non-disclosure makes any contract voidable. As all bankrupt corporations are operating for profit and they are not paying the taxes that they owe to the true American government, we the people. Tax evasion, fraud in representation or concealment in attempting to avoid payment of a tax legally due. As in the case of an income tax, the filing of a return fraudulently understated in a willful attempt to evade payment. Willingham v. United States 289 F.2d 283, 5th Circle 1961. Swallow v. United States 325 F.2d 97, 10th Circle 1963. A felony punishable by a fine of not more than $10,000 or up to F1V years imprisonment, or both. Internal Revenue Code Section 7201. The governmental bankrupt corporations are claiming exemption status as a charitable organization, but they're in fact operating for unjust profits. Concealment of securities. The offense, punishable by up to 7 years imprisonment, of dishonestly concealing, destroying, or defacing any valuable security, will, or any document issuing from a court or government department for the purpose of gain for oneself or causing loss to another. Valuable securities include any documents concerning rights over property, authorizing payment of money or the delivery of property, or evidencing such rights or the satisfying of any obligation. Disclosure of interest. The duty of local authority members to disclose, at the time or by prior notice to the authority, any pecuniary interest they or their spouses have in any matter discussed at a local authority meeting. They must also abstain from speaking and voting on it. Breach of the duty is a criminal offense. This includes bailment 5 payments into the retirement funds of all court agents, tax-free or never recorded on 1099s. Public Employees Retirement System, purse governmental bankrupt kickbacks from the security interest in the fraudulent governmental bankrupt tax payments obtained from the people and their property. When the bankrupt state is already holding the security tax interest income in the hidden-off budget comprehensive annual financial report accounts. Procuring breach of contract, inducing breach of contract, the tort of intentionally persuading or inducing someone to break a contract made by him with a third party. It is actionable by the party who suffers loss from the breach. This is done when the bar attorneys induce you to pay taxes out of your pocket because you have a contract with the state that they are to pay the taxes. Interfering with trade or business. The tort of deliberately interfering with the trade or business of another person by unlawful means, thereby causing damage to that person. Liability in this tort is wider than the tort of procuring breach of contract, since it is not necessary to show that an existing contract has been interfered with or broken. See Title 15 U.S.C. Section 1 and 2. Torture. N. The prohibition on torture is covered under the Civil Rights Act. It is also covered by the United Nations Civil Rights Protections, the offense of torture committed by a public official, or someone with the official's acquiescence, of intentionally inflicting severe physical or mental suffering on any person anywhere in the world. It carries a maximum sentence of life imprisonment. Under this act, the accused had a defense if he proved that his conduct was legally authorized, justified, or excusable. This right is an absolute right, and torture can never be justified as being in the public interest, no matter how great that public interest might be. Public authorities have a limited but positive duty to protect this right from interference by third parties. Ward of the state. A child becomes a ward of the state when a certificate of live birth or any state child contract is issued, is made, and the state's duty to the ward is to pay all bills, and it remains until she reaches the age of majority, 18 years old, or until a court orders that he should cease to be a ward and all entitlements restored to the ward. All courts are administering the Sestuike Trust without you. Roles of the Sestuike Vi Trust in a court setting. You, the living man/woman, are the beneficiary of the CQV Trust. The judge, whom is actually a magistrate, is the trustee of the CQV Trust. The clerk is the administrator of the CQV Trust. It is the clerk of court who is responsible for appointing the trustee and the trustee/executor for a court appearance, and it's really for constructing a constructive trust. That particular court case that you have been summoned/invited to make an appearance to attend. The clerk of the court is the beneficiary because the state owns you and you have no rights. A child becomes a ward of the state when a certificate of live birth or any state child contract is issued. The clerk of court, the pseudo-beneficiary, appoints the judge as trustee, the one to administer the trust, without you, and appoints the prosecutor as trustee/executor of the trust. The prosecutor is ultimately liable for the charge because it was she who brought the case into court. He is the one who created the constructive trust on behalf of the state, which charged the Sestuike Trust. Only a prosecutor/trustee can initiate/create a constructive trust, and we all know the maxim of law. Whoever creates the controversy holds the liability, and whoever holds the liability must provide the remedy. This is why all attorneys are mandated to bring their checkbooks to court, because if it all goes wrong for them, meaning either they fail to transfer their liability onto the alleged defendant, or the alleged defendant does not accept their office of liability, then someone has to credit the trust account in order to offset the debt. Since the prosecutor/trustee is the one who issues bogus paper and charges the trust, it is the prosecutor/executor/trustee who is in the hot seat. When the name, the trust, e.g. John Doe, is called by the judge/administrator/trustee, we can stand and ask, are you saying that the trust which you are now administrating is the John Doe Trust? This establishes that we know that the name is a trust, not a live man or woman. What's the judge/administrator/trustee's first question asked? What is your name, or state your name for the record? We must be very careful not to identify with the name of the trust, because by doing so makes us the trustee in breach of the trust, the surety. What does this tell you about the judge? If we know that the judge is the trustee, then we also know that the judge is the name, but only for this particular constructive trust. Now, think about all the times that the judge/administrator/trustee has become frustrated by our refusal to admit being the name that they issue on a warrant or summons. They become desperate because they must get us to admit to being the name, or they pay, and we must not accept their threats or coercion, or we pay. Because the judge/administrator/trustee is the trustee, a precarious position, the best thing to say, in that case, is John Doe is, indeed, in the court. Point to the judge, administrator, trustee. It is you as trustee. You are John Doe today, aren't you? Basically, courts are charging the all-caps name, which is a trust. They hope that you will identify yourself as the trust and give them access to the trust via your signature. In the corporate matrix, everything is held in a public trust, and the way the elite get access to the trust is to forge the trust and then get you to admit that you are the trust/name. During their frustration over our not admitting to being a trust name, the trustee and or executor of the trust, we ought to ask who they are.